had a somewhat unusual summer experience. I got ready to participate in a major Supreme Court case. The case that I worked on is called New York State Rifle and Pistol Association v. Bruin, and it's the most important gun control case in the last decade. In New York, you have to explain why you need to carry a gun. And, the obvious reasons you might need to carry a gun: you carry large amounts of money, you're a private investigator, maybe you're being stalked. And it is a kind of gun law that is becoming less and less common in America. The trend in America has been either to make it easier to carry a firearm, in some cases do away with almost all requirements. The question is that law now suddenly unconstitutional? And most interesting of all, is the law now suddenly unconstitutional because of historical reasons? What does a historian do in a case like this? My participation was in the form of helping to gather a bunch of scholars together to write an amicus brief. And an amicus brief is literally a friend of the court brief where scholars come together and try and present to the court vital information that they believe will help the court resolve an important issue. What my brief argued was that the New York law actually dates to the period of Reconstruction, the period after the Civil War, when Republicans tried to reconstruct the South, tried to bring it into the Union, but tried to bring it into the Union with a set of legal principles that would protect the rights of African Americans. So the New York law at issue is related to a series of laws that were passed during this period that required people to get a permit. And in order to get a permit to carry a gun, you had to prove that you had a specific fear. Couldn't be just like, I'm afraid stuff will happen. It had to be, I have a specific fear. And the argument in this case is that we don't generally treat rights like that today. We don't require people to prove they have a reason to exercise their rights. We generally just assume that government has to have a good reason to prevent you from exercising your rights. But what was so interesting about the case is in the oral argument, the justices didn't actually focus on the history. They seemed to be more interested in how requiring people to prove that they needed to exercise a right just didn't sit well with them. In fact, Justice Brett Kavanaugh said, this is not how we do rights. But to say this is not how we do rights is not an argument about history. It's not an argument about what the Constitution originally meant. It's very much an argument about American law today. They'll try to make it seem like the history supports them, but it's very clear the history doesn't support them. And so we'll have to see what happens.